Criminology Board Exam Reviewer. Evidence. Definition of terms. Part 1. Evidence. Evidence is the means, sanctioned by the rules of court, of ascertaining in a judicial proceeding the truth respecting a matter of fact. Principle of uniformity. It means that as a general policy, the rules of evidence shall be same in all courts and in all trials and hearing. Proof. It is the result or effect of evidence. Bare allegations unsubstantiated by evidence are not equivalent to proof. Factum probandum. It is the fact or proposition to be established. It is the fact to be proved, the fact which is in issue and to which the evidence is directed. Factum probans. They are the facts or material evidencing the fact or proposition to be established. The probative or evidentiary fact tending to prove the fact in issue. Relevancy of evidence. It states that evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. Multiple admissibility. It is where the evidence is relevant and competent for two or more purposes. Such evidence should be admitted for any or all purposes for which it is offered, provided it satisfies all the requirements of law for its admissibility therefore. Conditional admissibility. It is where the evidence at the time of its offer appears to be immaterial or irrelevant unless it is connected with the other facts to be subsequently proved. Such evidence may be received on condition that the other facts will be proved thereafter, otherwise the evidence already given will be stricken out. Curative admissibility. It allows a party to introduce otherwise inadmissible evidence to answer the opposing party's previous introduction of inadmissible evidence if it would remove any unfair prejudice caused by the admission of the earlier inadmissible evidence. Direct evidence. Direct evidence proves a fact without the need to make an inference from another fact. Circumstantial evidence. Circumstantial evidence or indirect evidence proves a fact in issue indirectly through an inference which the fact finder draws from the evidence established. Cumulative evidence. Cumulative evidence refers to evidence of the same kind and character as that already given and that tends to prove the same proposition. Corroborative evidence. Corroborative evidence is one that is supplementary to that already given, tending to strengthen or confirm it. It is additional evidence of a different character to the same point. Positive evidence. Positive evidence exists when the witness affirms in the stand that a certain state of facts does not exist or that a certain event happened. Negative evidence. Negative evidence exists when the witness states that an event did not occur or that the state of facts alleged to exist does not actually exist. Competent evidence. Competent evidence is one that is not excluded by law in a particular case. If the test of relevance is logic and common sense, the test of competence is the law or the rules. Competence, in relation to evidence in general, refers to eligibility of an evidence to be received as such. Credibility. Credibility refers to worthiness of belief, that quality which renders a witness worthy of belief. Burden of proof. Burden of proof or onus probandi traditionally refers to the obligation of a party to the litigation to persuade the court that he is entitled to relief. Burden of evidence. Burden of evidence is that logical necessity which rests upon a party at any particular time during the trial to create a prima facie case in his favor or to overthrow one created against him. Presumptions. These are inferences of the existence or non-existence of a fact which courts are permitted to draw from the proof of other facts. Inference. It is a factual conclusion that can rationally be drawn from other facts. Presumption of law. It is a deduction which the law expressly directs to be made from particular facts. Presumption of fact. It is a deduction which reason draws from the facts proved without an express direction from a law to that effect. Conclusive presumptions. These are presumptions which are irrebuttable and any evidence tending to rebut the presumption is not admissible. This presumption is in reality a rule of substantive law. Equitable estoppel. It states that whenever a party has, by his own declaration, act or omission, intentionally and deliberately led another to believe a particular thing to be true, and to act upon such belief, he cannot, in any litigation arising out of such declaration, act or omission, be permitted to falsify it. Estoppel by deed. It states that a party to a property deed is precluded from asserting, as against another party to the deed, any right or title in derogation of the deed, or from denying the truth of any material fact asserted in the deed. For example, the tenant is not permitted to deny the title of his landlord at the time of the commencement of the relation of landlord and tenant between them. Waiver. A waiver is a voluntary and intentional abandonment or relinquishment of a known right. It must be supported by an agreement founded upon a valid consideration. Unequitable estoppel may arise, however, in the absence of any intention on the part of the person estopped to relinquish or change any existing right, and it need not be supported by any consideration, agreement, or legal obligation. Disputable presumptions. Those which are satisfactory if uncontradicted, but may be contradicted and overcome by other evidence. Weight of evidence. It is the probative value given by the court to particular evidence admitted to prove a fact in issue. Sufficiency of evidence. In determining the sufficiency of evidence, what matters is not the number of witnesses but the credibility and the nature and quality of their testimonies. The testimony of a lone witness is sufficient to support a conviction if found positive and credible. Falsus in uno, falsus in omnibus. It means false in one thing, false in everything. Alibi. It is a defense where an accused claims that he was somewhere else at the time of the commission of the offense. It is one of the weakest defenses an accused may avail because of the facility with which it can be fabricated, just like a mere denial. Out-of-court identification. It is a means of identifying a suspect of a crime and is done through show-ups, mugshots, and lineups. Show-ups. It is where the suspect alone is brought face to face with the witness for identification. Mugshots. It is where photographs are shown to the witness to identify the suspect. Lineups. It is where a witness identifies the suspect from a group of persons lined up for the purpose. Corpus delicti. It is the actual commission by someone of the particular crime charged. It refers to the fact of the commission of the crime, not to the physical body of the deceased or to the ashes of a burned building. The corpus delicti may be proven by the credible testimony of a sole witness, not necessarily by physical evidence. Proof beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof as, excluding possibility of error, produces absolute certainty. Moral certainty only is required, or that degree of proof which produces conviction in an unprejudiced mind. Moral certainty. Moral certainty is that degree of certainty which will justify the trial judge in grounding on it his verdict. It is a certainty that convinces and directs the understanding and satisfies the reason and judgment of those who are bound to act conscientiously upon it. Preponderance of evidence. It is the weight, credit, and value of the aggregate evidence on either side and is usually considered to be synonymous with the term greater weight of the evidence or greater weight of the credible evidence. It is a phrase which, in the last analysis, means probability of the truth, evidence which is more convincing to the court as worthy of belief than that which is offered in opposition thereto. Substantial evidence. Substantial evidence applies to cases filed before the administrative or quasi-judicial bodies and which requires that in order to establish a fact, the evidence should constitute that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. Clear and convincing evidence. It is that degree of evidence that produces in the mind of the trier of fact a firm belief or conviction as to allegations sought to be established. It is intermediate, being more than preponderance, but not to the extent of such certainty as is required beyond reasonable doubt as in criminal cases. Judicial notice. It is the cognizance of certain facts which judges may properly take and act upon without proof because they are supposed to be known to them. It is based on considerations of expediency and convenience. It displaces evidence, being equivalent to proof. Mandatory judicial notice. It is when the matter is subject to a mandatory judicial notice, no motion or hearing is necessary for the court may take judicial notice of a fact. Discretionary judicial notice. It is when the matter is subject to discretionary judicial notice, a hearing is necessary before judicial notice is taken of a matter. Doctrine of processual presumption. In international law, the party who wants to have a foreign law applied to a dispute or case has the burden of proving the foreign law. Where a foreign law is not pleaded or even if pleaded, is not proved, the presumption is that the foreign law is same as ours. Judicial admissions. These are admissions, verbal or written, made by a party in the course of the proceedings in the same case, which does not require proof. Extrajudicial admissions. Admissions made out of court or in a judicial proceeding other than the one under consideration. Actual admission. It is when a party categorically admits a material allegation made by the adverse party. Implied admission. It is when the admission is inferred from the failure to specifically deny the material allegations in the other party's pleadings.